All right. Welcome back. So I hope you had a great day yesterday, and you watched the video and you filled in the notes and answered the questions that go along with the other two videos. Those ones were on YouTube. This video is for Tuesday, January 27th. Explain the role of the Equal Protection Clause in the 14th Amendment as the legal basis for the civil rights movement. So I encourage you to pause the video to answer that question. And I'll take just a minute to explain it. The 14th Amendment, if I can jump back here, talks about denying. Let me get this video out of my way here. Talks about denying any person within its jurisdiction equal protection of the laws, right? So equal protection of the law, what that means is that the laws have to be neutrally applicable to everybody. And in Jim Crow South and Jim Crow laws, those laws were not neutrally applicable, right? And so when the civil rights movement came and argued in favor of the equal application of the law, that's what they were doing. And so it was kind of the legal basis for it, right? The civil rights movement is usually studied as a political and social movement, and that is very much what it was. But it also originated in a legal sort of underpinning, if you will. So that is. That's why, and really that's where they got that from. It started with the Brown versus the Board of Education, which was the school integration Supreme Court case, where the justices on the Supreme Court said that separate facilities for different races violated the 14th Amendment because separate but equal was inherently unequal. And we saw that in the Crash Course U.S. History video, saying that just by putting them in separate schools, you were telling black students that they were inherently unequal. And so they used the Equal Protection Clause of the 14th Amendment to be the basis for the civil rights movement from a legal standpoint. Also want to talk about some other examples of civil rights. Civil rights is often thought of mostly as a topic when it comes to race and specifically for Black Americans. But there's other examples of civil rights as well, because civil rights are what stops the majority from infringing upon the rights of the minority. And so another example is maybe the rights of indigenous people. The Indian Citizenship Act of 1924 gave citizenship to all Native Americans. Remember, the 14th Amendment says all persons born in the United States are a citizen of the United States and the state they reside. But there's a clause in there that most people don't think about, which is, and subject to the jurisdiction thereof. And for a lot of the conversation was, well, does that include Native Americans? And the answer was, up until 1924, was no, right? And so in 1924, they passed a law. They called it the Indian Citizenship Act, and that gave citizenship to those indigenous people. The Indian Reorganization Act in 1934, that gave Native American tribes the right to organize reservations on their own land, and that land kind of exists in a semi-sovereign sort of way, in a way that doesn't really exist in any other sort of way within the United States. And then the American Indian Religious Freedom Act of 1978 basically recognized American Indian religions as, I guess, valid religions under the First Amendment. There's also the age discrimination. In this country, it is illegal to discriminate for employment, for example, on the basis of old age, which is interesting, because young age can be something that they discriminate on. Business could discriminate against you for your youth and lack of experience, but they cannot discriminate against an old person on the basis of being old. And that is, I think it's interesting, and there's an interesting political reason to that, and that is that old people vote and they donate money and they are politically organized. And so when Congress passes a law for age discrimination, they're going to do it for old people and they're not going to do it for young people, because young people don't vote and they don't donate money and they're not politically organized. And so that's just kind of the reality. Now, that doesn't mean that old people are just going to get whatever job they want. That's obviously not the case. There are sometimes requirements for jobs, like being able to lift things or be able to do certain things with technology that might not necessarily be something that somebody might be able to do, but that has to be listed in the job description. It can't be because a person is too old. There's also the Americans with Disabilities Act and the Rehabilitation Act, Section 504. Thinking about the ADA, the Americans with Disabilities Act, this is actually such a prominent part of our life. Every parking lot has a certain number of handicap spaces. Every public restroom has a handicap stall. The doors have to be a certain width. They have to have grab bars and things like that for bathroom stalls, and elevators and ramps and all these different things in order to make something compliant with the ADA. But this was again another example of if a business didn't want to pay to retrofit their restroom a certain way, and they didn't want to have a certain number of handicap spaces because they wanted to use their parking for other customers, right? It might make sense for one business to just do that and not have those things like that. And that would be an example of the majority infringing upon the rights of the minority, not because they don't want handicapped people there, but because there's maybe a business decision that could be made with this says, if I have to have 3 handicap parking spaces and they have to be double wide, I could have 6 regular sized parking spaces and fit more cars there. If I have to have a double wide handicap stall, I could have 2 regular sized stalls in there, and it costs more money, and it you have to build a ramp and things like that. And so there might be a business reason to say, it's not that I don't want handicapped people at my establishment, but it's just not worth it. It's just not worth the extra cost. And so they don't come here. They have other places they can go. But the problem is that maybe they don't. And so the American Disabilities Act, that was an example of Congress passing a law that protected those civil rights. Gender, there's the Equal Rights Amendment we've talked about already in class, which would guarantee equal legal rights regardless of sex. And then Title IX. Title IX is guarantees athletic equality, educational equality for sex. A lot of times that means athletic equality as well. So a lot of times that's kind of the basis for women's sports in high school and college levels. And then LGBT rights. Obergefell v. Hodges in 2015 was the Supreme Court case that said that the 14th Amendment applies to same-sex marriage. So basically, that part about the laws. Let me jump back here. Nor deny to any person within its jurisdiction equal protection of the laws. Right. So that important equal protection clause. The Supreme Court in 2015 says that applies to gay marriage. So basically that a state could not have a law that would require marriage to be between only a man and a woman, because that would basically be discriminatory under the 14th Amendment to gay couples. In 2022, now, that was just a Supreme Court decision. Supreme Court decision is not law. It's something called common law. We'll get to in a few weeks. But what that means is that is an interpretation of the Constitution that invalidates state-level laws. And so in 2022, there was also a law passed. It's called the Respect for Marriage Act. And basically what that is it became now congressionally passed law signed by the President Biden at the time, that basically makes it so that marriage can be including same-sex marriage. Okay, so those are some other examples of civil rights. So we haven't really talked about civil liberties yet, and so I'll probably copy this slide and bring it back over to the civil liberties PowerPoint as well. But civil liberties are granted freedoms that restrain governmental power, right? So these are the unalienable rights given at birth, and those are spelled out in the Bill of Rights. Civil rights, on the other hand, they grant freedoms from discrimination under the law. They're implemented through government action, and they ensure certain groups are not denied their inalienable rights. So the difference is here, who is being restrained? With civil liberties, it's the government that's being restrained. With civil rights, it's the government that does the restraining to prevent private actors or even smaller governments from taking the civil rights of other groups, right? So we have, I've got this video here, and then these questions. These questions are in your notes. I can't play the video on this video, and the reason is because YouTube will make it a copyright strike. So what I'm going to do is I'm going to attach this video, and you can answer these questions, and then there's kind of a part 2 with the questions as well, and we will talk about this either in class on Wednesday if we're in person, or I'll make a video for this tomorrow, but we will see. So I hope you're doing well. I hope this time with the snow day is going well for you. Once again, make sure that you at some time join the Google Meet, and if you cannot for whatever reason, please send me an email. All right, thanks.